88. The court should take at face value the videos and statements within them that are careful not to invoke extra-curial violence, but telling listeners to be careful of what had to be the operation of law once the matter was before the Hague. He also admonishes people who might attend that they must not be violent. In fact, what the defendant is advocating is for people to assert their rights, but if you are forced to, go peacefully and keep a diary of the interaction. 88 is another important clause in that the Justice has pointed out that we have been very careful not to invoke any extra-curial violence coming from a different crown, but telling listeners to be careful of what he had seen as the operation of law, the international laws of armed conflict, which separate these two powers on the table. He also admonishes people who might attend that they must not be violent. Well, you can't be. This is a very large Gandhi situation where you have an administering power on your soil about to digital ID all of you and turn you into a WEF nightmare. Violence is not the answer. In effect, what the defendant is advocating is for people to assert their rights. But on the flip side to you asserting your right is the police trying to stop you from asserting that right. And if they are to try and stop you, document the interaction, keep a diary of the interaction, and just walk away peacefully. Don't interact with these policy enforcers at all. 87. The court could find that what the defendant is advocating is not conduct in support of violent actions, but rather application of what he believes might be the result of due process of law, and so it is in effect an extreme political view advocating political change as opposed to an extremist view advocating illegal violence. So the Justice is hinting that it is similar to politics in nature, but is extra-curial in nature instead. We understand that violence leads to a nanny state using its rules against us, giving the police an excuse to react, and getting a reaction is what they want. So the advocating not to go in violence detracts or takes away from the police the ability to react. 86. There is no evidence that the defendant intended to cause physical harm to any person or endanger lives by his actions. The calling for curial overthrow of the government does not amount to a terrorist act or calling for curial punishment. The court should view any statement that a person or class of persons will be punished in a particular way, even by capital punishment when the law is changed, is quintessentially political advocacy, no matter how offensive or uncomfortable those threatened by it might be. So going backwards from 88, 87, 86, we can see that we have a curial right, a crown right, and calling for a crown overthrow of government does not amount to a terrorist act. Removing what could be called a foreign crown from your curial standing, your crown, could be seen as the answer to reversing what happened to Gough Whitlam in 1975 when he was thrown out of government. A curial overthrow of the government is what happened when they removed your Crown from power over 20 years and then finally kicked Gough Whitlam out. It is the reversing of this curial overthrow that happened in 1967, and it can be done by sheer unity of the people in their hearts and minds to know that it exists. In respect of Section 10(1)(c) of the Act, the defendant submitted that neither he nor the United Kingdom of Australia have advocated support for a terrorist act or violent extremism. Section 2 factors must be borne in the mind, as must Section 101A and its interaction with Section 101(3) of the Code, that effectively excludes certain activities from the definition of terrorist acts. So what the Justice is pointing at here is that the United Kingdom of Australia, coming from a curial foundation, a Crown foundation, is effectively excluded from committing terrorist acts because it becomes party to something else. And the judge alluded to that already in that the operation of the law before The Hague. It's not just The Hague, but we see an international body of law that is being hinted to by the Justice. And 85, in that the United Kingdom of Australia falls factors that must be borne in mind, that effectively exclude certain activities from the definition of, quote, terrorist acts. The United Kingdom of Australia is the occupied territory in this equation and therefore can't be deemed to be the terrorist. This is the conundrum that the Justice had when talking about this last clause. Fundamentally, however, I dismiss the state's amended summons because I am not satisfied to the requisite high degree of probability. There's a fundamental problem at law which is now being brought up in this clause here. In respect of the Act, neither he nor the United Kingdom of Australia have advocated support for a terrorist act or violent extremism. Section 2 factors must be borne in mind, as must Section 101A and its interaction with Section 101(3) of the Code, that effectively excludes certain activities from the definition of, open quote, terrorist acts, close quote. The calling for curial overthrow of government does not amount to a terrorist act. The court should take at face value the videos and statements within them that are careful not to invoke extra curial violence. The clarity that the judge has given between 84 and 88 is rather stark. It's a stark reminder to the government that it is in a curial administrative position. It's a stark reminder to all of you that there is curial violence that could take place and you are not to invoke any of it. Going backwards, we can see that this organisation is curial in nature, has been warned not to perform any curial violence, in its call to arms has brought together the families of the communities with their coats of arms rather than weapons, which the curial nature of this doesn't afford them the ability to hold anyway. So there is no gathering with your flags with weapons. But being the curial occupation that it is, there has been a disarming of an occupied peoples. It's what John Howard did to you all in 1986 at the time of the Australia Act. What the judge means is that we have an extra curial right. We understand that violence leads to a nanny state using its rules against us, giving the police an excuse to react, and getting a reaction is what they want. So they're advocating not to go in violence detracts or takes away from the police the ability to react.